The case involving a young pharmacist, Solomon Akuma, who was arrested on April 2, 2020 in Aba, Abia State, for allegedly making social media posts against President Muhammadu Buhari and his late Chief of Staff, Abba Kyari, was heard on Monday, September 27, 2021. Akuma is facing trial on charges bordering on terrorism, sedition, criminal intimidation of the president, and threats to his life. During the hearing, there was drama as the prosecution lawyer, Victor Okoye, in an attempt to cite an authority, pronounced the Nigerian Weekly Law Report as NORL in response to the argument of the defense counsel, who had submitted that only the Attorney General of the Federation has the power to prosecute the charge bordering on terrorism. The trial judge was compelled to ask the prosecution counsel the meaning of what he wanted to pronounce, but he said he did not know it. He could not also proceed with the citation as he remained mute for about 5 minutes. Meanwhile, the defense counsel, Emmanuel Ukaibu, after he had adopted his written address, submitted that the charge upon which the defendant was facing trial was not filed and that it was just an exhibit to the motion on notice. He added that on that ground, the charge was not competent and valid. Also, on counts 5 and 6, which bordered on terrorism, Ukaibu argued that the act upon which the charge was brought mandated that only the Attorney General of the Federation had the power to prosecute the defendant on any issue arising on terrorism. He added that the Nigerian police have no such power to prosecute the defendant. Ukaibu also submitted that none of the counts mentioned where the purported crime was committed by the defendant, which he said was an essential ingredient on any criminal case. He cited the case of Belgravia vs. FRN 2021 NWLR page 503, where the Supreme Court was specific that every charge must state clearly where the crime was committed, which was completely missing in the submission of the prosecution counsel. Also on count 7, which bordered on treasonable felony, the defense counsel explained that none of the prosecution witnesses made any reference in their statement to the offense. He therefore urged the court to dismiss all the charges brought against the defendant, discharge and acquit him. After listening to the submission of both parties, the judge adjourned the case to November 22, 2021 for judgment.